Good afternoon, everybody. I'm Miguel, and I'll be presenting on R.V. Smith, which was a landmark case regarding Section 12 of the Canadian Charter. So this presentation will focus on two landmark cases, which would be, as I said, R.V. Smith, and I'll reference as well R.V. Dillon, which occurred last year. These cases help us understand how Canadian courts interpret what it means to be protected from cruel and unusual punishment and how this protection is applied in real-world sentencing decisions. So we'll begin with the law itself. So Section 12 states that everyone has the right not to be subjected to any cruel and unusual punishment or treatment. This section is a key part of Canada's constitutional commitment to human dignity and fairness. It basically exists to prevent the government from imposing sentences or forms of treatment or punishment that are inhumane or excessive in regards to the offense itself. So, as was explained in our course materials, Section 12 protects against both punishment, like incarceration, and treatment. So, that would be like state imposed conditions that would include like solitary confinement. The courts have said that punishment becomes unconstitutional, however, when it's so excessive as to outrage the standards of decency or that it's just grossly disproportionate in relation to the offense or offender. Going back to the R.V. Smith case, essentially this was a Supreme Court case, and it is one of the most important early decisions interpreting Section 12. It came out very recently after the Charter itself was written. So, essentially, what happened, the facts of the case are that Edward Smith was convicted of importing 7.5 ounces of cocaine into Canada. At the time, the NCA or the Narcotic Control Act imposed a mandatory minimum of 7 years sentence for drug importation, regardless of the circumstances. So that would disregard the fact that it was Smith's first time, and it would also disregard the small amount of cocaine that he had on him. So the legal issue here was that, what was the mandatory sentence cruel and unusual under Section 12? And so the Supreme Court struck down the mandatory minimum of 7 years, and they ruled that it was grossly disproportionate in some reasonable cases, so that it violated Section 12 of the Charter. The ratio states that the court set out a clear test for when a punishment violates Section 12. This case essentially created that. So, for it to violate Section 12, it must be so outrageous to public decency, it must be degrading to human dignity, it must go beyond what is necessary for the law's purpose or arbitrarily imposed. And the courts also emphasized that when evaluating mandatory minimums, judges can use reasonable hypotheticals, basically imaginary scenarios where the law would just apply unjustly. Even if the sentence is appropriate for one offender, it can still be unconstitutional if it would lead to cruel outcomes in another case that could likely happen. This case also made it clear that prosecutorial discretion is not an adequate safeguard when charter rights are at stake because it can apply differently to anybody. And now we'll talk about Dylan, um, which occurred last year. So last year in 2024 and early 2025, John Dillon, a 19-year-old Indigenous man from the Northwest Territories, pleaded guilty to making child pornography or what was called child sexual abuse material in the case, which is a crime that carries a mandatory minimum sentence of 1 year in prison. The judge, however, found that the mandatory minimum sentence violated Section 12 of the Charter. This is because Dylan's actions were serious, but the judge considered his youth, his lack of a criminal record, and his indigenous background. The offense could have been committed in many different ways as well, so that can change how serious the offense is. So, based on those factors, the judge ruled that the law was grossly disproportionate in its broader application, even if it wasn't necessarily cruel in this specific case. He applied the R.V. Smith test, which was looking at whether the mandatory minimum could lead to unjust outcomes in other situations. Instead of jail, Dylan received a conditional sentence of house arrest for 2 years less a day, followed by probation, along with restrictions in community service. The judge particularly emphasized the importance of rehabilitation and reintegration, especially for young and first-time offenders. This outcome of this case shows a proper implementation and interpretation of Section 12. Section 12 is not meant to just change whatever sentence someone gets. It's meant to guide the courts and everyone into making a correct and a proportionate decision. As with the Dylan case, it was his first time. He was very young, and obviously with the indigenous background that he has, and the fact that the crime could have been committed in several different ways, that kind of mitigates a lot of the circumstances. However, on the other hand, if Dylan was much older, if he had a lengthy criminal record and other factors that aggravate it, most likely they would not have changed the mandatory minimum. And so this all connects with the course content because it's developed a test which was mentioned in our lecture. And the test itself asks two questions. It requires two key aspects. Firstly, was there a treatment or punishment by government action or law? In R.V. Smith, there was. And adding on to that, was the treatment or punishment cruel and unusual? And in both Dylan and Smith, they were both found to be either cruel or unusual. Um, this case, the R.V. Smith case, also connects with the course content as it mentions the mandatory minimum sentences and how the courts must consider whether the sentence is disproportionate either to the individual or to a reasonably foreseeable hypothetical situation. So, what that essentially means is, regardless of the particular individual that's in front of the courts, in any case, could this punishment be seen as unreasonable or cruel? And in both cases, of course, they were, but it causes lawmakers to change or trend into a different path when it comes to creating punishments for particular crimes. So this doesn't mean that all mandatory minimum sentences violate Section 12, only that the punishment must be reasonably administered to the offender while considering the facts of the individual case. The prosecutor's discretion cannot override this. So, as I just said, it is only a guidance and still depends on each individual case. And the reason for this is that the purpose of the charter is to balance punishment of crime with the state power. It protects from abuse of power by the state. Without this particular section of the charter, you could have very unreasonable punishments for things that simply the state determines as bad or punishable. So the purpose of the punishment in Smith is to curb a serious offense. It's still deemed disproportionate and harsh when in relation to individual circumstances. As I've said, it was a very small amount of cocaine and it was his first time. He was also carrying it for a friend, which I don't think was mentioned, but that is very important. It's a mitigating factor. And when you take into account all those mitigating factors, you kind of look at the case and you're like, well, this guy I don't think deserves a mandatory minimum of 7. He did mess up. It was very serious and he should have known better. However, it's not like cases where people are bringing 200 kilos of heroin or cocaine into the country. And when analyzing Section 12, this has basically established legal principles that are still very important for us today, even though this case came out in or occurred in 1987. So, as was said before, the courts can use reasonable hypothetical scenarios to test whether a law breaches charter rights. Essentially, that's like a guessing game of what if scenarios. And if any scenario can lead to something that is grossly disproportionate in terms of a punishment, that can lead them, the lawmakers and judicial officials, to call out something for being grossly disproportionate. As was said before as well, the mandatory minimum sentences are not inherently unconstitutional, but must be consistently proportional and with individual circumstances. So, my discussion questions are: how does the understanding of proportionality shape the court's approach when it comes to mandatory minimum sentences? And my second is: why would prosecutorial discretion not be enough to protect against unconstitutional punishment under Section 12? And so, to conclude this presentation, Section 12 of the Charter protects individuals from state imposed penalties that are disproportionate or inhumane. And in R.V. Smith, the Supreme Court established that the test for unconstitutional punishment should be as is, whether there is a punishment or not, and whether that punishment is essentially extreme. In Dillon, a territorial judge applied the same reasoning to rule that a mandatory 1 year sentence was too harsh in its possible effects, proving that it is still very relevant in a modern day setting, or much more modern day setting. These cases just show the importance of how individualized justice and highlight how the courts work to ensure that punishment is not only fair, but also respects human dignity. Thank you for listening, and good luck for the rest of the year, guys.